Hi, everyone. David Graff with Moeller Graff. Today we're talking about towing. And if you thought community associations and community association boards were hated by the Colorado legislature, just be thankful that you do not own a towing company. Now, it's not without facts to support additional regulation. Obviously, there were a couple of bad actors, one in particular that is no longer in business. That, at least in the eyes of the legislature, and to some extent, the Public Utilities Commission, which is the state agency that regulates towing, felt that they were predatory. Now, the governor, mind you, or remind you, said that HOAs were predatory in a press release about 2 years ago. So there's a lot of that suspicion going around. But towing has been, uh, you know, regulated for years by the Public Utilities Commission and by Colorado statute, significantly overhauled in 2022, and then revised at least once, if not twice, since then. And it's becoming a contentious issue, of course, and it's becoming difficult to do. And that's by legislative design. So I'm going to talk, hopefully, in an orderly manner about some of the things that we worry about, just large concepts first. Then I'll talk a little bit about, or as much as there is to talk about, the procedural requirements for towing. And then I will talk about the new booting law that took place that was signed by Governor Polis this year in 2025. That was House Bill 1117. And the term that they use for booting is vehicle immobilization, but that is now a law. It's pretty similar in scope, regulatory scope and requirements, similar to the towing statute, but we'll talk about that as well. Let's see, just making sure if anyone wants to. Mary, you just joined us. I'm going to allow you to talk. It may ask you to unmute yourself. You don't have to, and you can stay muted. But if you did need to ask a question, feel free to do that. Same with anybody. Okay, let's get started. So oh, I forgot my disclaimer slide, but this is educational use only, right? A lot of the stuff in here I'm going to be talking about is the tip of the iceberg, summary of the statutes. And please don't, this isn't legal advice. Don't rush out and tow vehicles based on what I say today. With that disclaimer aside, there's a threshold or a basic determination that has to be made in terms of how associations regulate towing. And that is, do we need to follow the requirements of House Bill 1137 from 2022? As you may recall, House Bill 1137 has a 72-hour cure for violations, covenant violations that threaten the public health and safety, and a 67-day cure period for covenant violations that do not threaten the public health and safety. And so there's an argument that undoubtedly will go to the Colorado Supreme Court someday as to whether you have to follow 1137's notice and cure period before you get to the towing statutes. And there's an argument against that. Now, I personally believe, I can't give you a case because there hasn't been one yet saying this, but I think there's a very good argument that towing is what we call self-help, which means we're not pursuing a fine, we're not pursuing legal action, which are two of the buzzwords that would require you to follow 1137's notice and cure period. So, and in fact, the covenant violation policies that we've been writing since 2022 say that self-help is exempted from or excluded from the requirements of 1137. However, when we're saying someone did something wrong, I don't mean morally wrong, I just mean they parked in the wrong place. It has to be peeled back to something in the association's governing documents, which means it's technically a covenant violation that they're parking in a fire lane or they're parking, in the parking lot without the right tags or what have you. And so that's the argument in favor of saying it has to follow the 1137 notice and cure period. Not to sound like a ping pong player here, but another argument against it having to follow that notice and cure period is that, number one, The towing law, originally, the big landmark towing legislation came down in 2022, which was the same year that 1137 came down. And in the towing law, which is in Title 40, it's 40-10.1-401, and the booting is 803 or so forward. That's where the statutes can be found in the Colorado Revised Statutes. The towing bill, now a law, refers to Kiowa. So there's obviously a recognition that when they adopted the law on towing, they knew that HOAs existed. They talk about a community manager that has the authority to regulate parking as an example. And it doesn't say anything about following 1137. And so had they intended for us to do both, they certainly could have made it abundantly clear. And the challenge is not it's not philosophical. It's like, oh, should we do follow 1137 before we get to the towing bill? It's a practical one. Because unless it's a fire lane, right, and you have to make an argument that parking in a fire lane violates the public health and safety, which I think you could make that argument. That's why it's a fire lane. But for all these other violations, if we had to give two 30-day notices before we could then give 24 hours notice, it just defies logic that that would be the intent, right? The towing law is very clear in this regard. If the requirements in the statute have been met, the towing carrier can tow a vehicle non-consensually, that's the term in the statute, with either 24 hours notice, prior notice, or no prior notice. It says nothing about notice and cure 67 days, 72 hours. It says 24 hours or no notice. That's it. So I think the better argument is the only practical way to regulate towing, especially if it's not a public health and safety violation, is to not give 67 days. Because I promise you, as a practical matter, it's virtually impossible for associations to tow when having to give owners 67 days. We don't keep that type of data to validate the car moving or not moving. And there will be, this is maybe my retirement plan, parking regulation with RFID chips in parking passes that will monitor the vehicles coming and going. And we can know exactly when it got in, when it stayed there, how long it stayed there, when it left, or if it didn't leave. Right now, we don't have that to my knowledge. So the safer way to go, the way that you could enforce parking is to consider it a covenant violation and follow the notice and cure period in 1137. It would take the risk to zero. However, I believe it would also reduce the effectiveness of any effort to almost zero as well. So just beware of the argument. I don't know if most practitioners are, I don't know what other people are saying from the law firms. I haven't had a conversation on this topic. But just be aware that that argument lurks in the background. I think it's a bad argument, but it's an argument that can be made. And that's why it matters. Sorry, I'm behind on my slides here because of the notice and cure period. So in 2022, there was another law, a law that I fundamentally disagree with very deeply, but it doesn't really matter what I care about. The legislature is going to do what it's going to do, and that's okay. But that was the regulation of public rights of way. Again, 2022 law signed into effect. And what it basically tried to say, I think, is that associations can't regulate behavior on or uses of public rights of way. And as a general rule, that means streets, but it could mean tree lawns and everything else. And that can be found, that statute, in 106.5 of Kiowa. Now, sarcasm diminishing, this section of that statute is really reducible to two sentences. And those two sentences arguably conflict with each other. The first sentence is, the association shall not prohibit the use of a right of way if it's being used in accordance with government requirements. An outgrowth of that would mean that if someone is using the public right of way out of standards set by the municipality, city or county, then the association can enforce it. But if the homeowner is doing what they're doing in compliance with government requirements, then there's nothing we can do beyond that. That's argument one. The second sentence, though, says we cannot require a right of way be used in a certain manner. Does that mean that we can tell people they can't park on the public right of way? I think that's the intent of the statute, but they messed it up clearly. And so there's an argument, I'm not saying it's going to win, that associations can regulate public rights of way if to the extent that we're bringing the behavior in line with what the municipality allows or requires. There's perhaps a stronger argument or an argument that you could make that takes zero risk that says associations can't touch public property at all. And so it's a mixed bag. I think most of our clients, I don't know about most, many of our clients are saying public streets, we're out. And meaning we're not doing anything about it. And the skeptics on the call here are probably wondering, well, wait a minute. If the association does not own the underlying ground, meaning the public street, then what business does it have regulating parking on the public street? That's a great question. And the answer is the declaration can say, you owner cannot park in the public streets within our community, or whatever the language is, as long as it's very precise. And by contract, all the owners who buy homes agree that they will not do that. And there are two cases in the United States, last I checked, that stood for this proposition that that was a legally binding contract and that the underlying ownership of the ground where the conduct is regulated is irrelevant. And that had been chipped away a little bit by some municipalities. Notably, Parker had an ordinance from many, many years ago saying you couldn't do that with certain caveats. But yes, associations did, before this 2022 law, have the ability to regulate parking on public streets. And I've been to trial on it, and I know most other community association lawyers have gone to trial on it. And now I don't know the state of all of the enforcement on public streets, but I anticipate there will be an appellate case soon. And I hope and pray that it's not one of our clients that has to bear that expense. So this is the trash toter, parking, all of these behaviors that people might not be able to do on their homes may now be able to do on the public rights of way. And just be aware of that. Some of our clients, probably a number of them, not a number of them, more than a few, have a mixture of public and private property. As an example, sometimes townhouse communities will have public streets running throughout them, but they will also have private parking areas that are owned by the association. Condos, similar. So we just want to make sure that we know, if we're going to tow, is it on public property? And if it is, then we have to do this additional analysis as to whether we want to and whether we can regulate it. If it's private property, we don't have to go through this step. Just be careful. If it's public right of way, be extremely careful. And if it's private property, we don't have to worry about the public right of way law from 2022. We just need a document, rules and regs or covenant. It doesn't have to be a covenant, I don't believe, if it's common area, because the associations, whether condo or planned community, have the authority to regulate common area. But we want something on our books as an association saying you can't park here, or you have to park here under these conditions or satisfy these requirements, right? Because if we tow a vehicle, let's say from a parking lot, even if the association owns it, and the homeowner says, well, where does it say that I can't do this? And you're going to want to have a piece of paper in your governing documents that says this is where it says you can't do that. And if you don't have that, then your case is, said very politely, extremely weak. It's probably also a good idea to have a towing policy. And I think especially if you're doing vehicle immobilization or booting, because there's language about apartment houses and giving every tenant a copy of the regulations on and vehicle immobilization. we just want people to know what they're expected to do or not do, right? And that would be the best first step. And the second defensive step would be, and if they're not going to read what we give them, then we want to be able to justify what we did as being proper. And it has to be tied back to something in our documents that said you couldn't do what you did. And the consequence of that, depending on what intermediate steps there might be, the consequence is your vehicle was towed at your expense. Go pick it up. Now, 4010-105 is the primary statute. It's not the only statute, but that's where you find most of the restrictions on towing that affect common interest communities. And it's the non-consensual tow statute. It's pretty easy to do a consensual tow. And by that, we mean a tow with the permission of the vehicle owner. Because we're not the vehicle owner, it's a non-consensual tow. And again, part of this, the reason that second bullet point says carrier cannot tow unless authorized is they want to pin the towing carriers down. They want, this is my opinion, based on the language, they're binding or scaring or requiring the towing carriers to make sure that we do everything right as well, which is not an unreasonable thing to do. It's not unethical, and it makes practical legislative sense, which is okay. Association has certain things that it has to do under the statute, but ultimately we're saying that the towing carrier can't tow unless these things have been done. And I've heard some scuttlebutt from professional managers. I haven't heard anything from the board that I can recall from a board that says the reputable towing companies are extremely skittish on towing, as they perhaps should be if they want to continue to tow from non-consensual private parking areas. So can't tow unless properly authorized. And the statute talks about authorization, who can do that. And we, as an association, can do that if it's in the association's parking lot or in the fire lane, and it's not meeting the requirements of our regulations. Now, it's important to note that, well, and I don't think I have a slide for this. The towing carrier can't be the one that authorizes the tow. Now, it used to be, prior to 2022, that you could hire a towing company to be your parking lot monitor, and they could keep photographs and license plate registries. And if they found a vehicle in violation of the association's policies, you could just tow it immediately. I mean, depending on, usually, back then we used to do 72-hour prior notice, but they would tag it 72 hours because that was then the Public Utilities Commission threshold for towing. And then it became now it's a 24-hour tow, but that is no longer possible. And it makes legislative sense to say this, which is the towing carrier, the bad guy in the eyes of the legislature, shouldn't have a financial interest in towing vehicles. They shouldn't be the hen patrolling the hen house. That's why they can't be the monitoring company. So you could have a separate monitoring company. Most of our clients, to my knowledge, depending on the size and how many parking spaces they have to regulate, often have a board member, or they have a manager report to a board member that the board member typically authorizes the tow. And the tow authorization has to be received within 24 hours before the tow occurs, which is interesting. So, you couldn't authorize a tow on Tuesday and send it to the towing company, and then by Friday they tow the vehicle. It has to be within 24 hours, and it has to be authorized for each specific tow. And that sounds obvious, but if you had a whole bunch of cars in a parking lot that was about to be repaved, and you gave them notice and called people and wrote letters and everything else, you can't just issue a blanket authorization to the towing company. Yeah, yank them all out of there. You can't do that. So that's why I put that in, just as a reminder. Now, who can authorize the tow? Well, it can't be the towing company, but it could be a board member, and it could be the manager, I think. Seems reasonably clear in the statute, but I have heard that some towing companies are saying, no, I don't want the manager authorizing the tow. I want the board to authorize the tow. And that's been my experience. You'll just have to find that out yourself if you haven't already. And the authorizer cannot have, meaning the authorizer of the tow. I do have a slide for this. You can't have a financial interest in the towing company, or if there's a parking lot management company, that's that conflict of interest. It makes logical sense that you shouldn't be able to profit from your towing. So you can't do it. Now, there's notice requirements for the vehicle. 24-hour notice in many cases, in not all cases, but it has to be notice on the windshield. Let me go back. And it has to say very specific things. Oh, and by the way, there's a Public Utilities Commission form for authorizing the tow that your towing company will typically provide to you. The statute says that the commission, the PUC, Public Utilities Commission, will establish a form for that. They did. And it's not magical, but it has the specific requirements. And so we have to put this, someone has to put the notice on the windshield of the vehicle at least 24 hours before the tow. And then once the tow is authorized, the tow has to be done within 24 hours after that. So one is at least 24 hours, and the other one is no more than 24 hours. So just be aware of that. Now, here's what probably most of you want to know. Do we have to give 24 hours notice in every case? And the answer is no. By statute, you don't have to give 24 hours notice in every case. Could you? Sure. If you were to do that, though, you want to make sure that you're not picking and choosing who gets notice, right? So you don't have to give notice under the statute if the vehicle was twice tagged previously for inappropriate towing. Maybe they don't have the right tag, maybe they're parking in the wrong spot, whatever. The court or police authorized the tow. Had some interesting conversations about this recently where the police officer is telling the board, our client, oh yeah, you can just tow it. And the towing company is telling the manager, oh no, I'm not going to tow it. Board gets angry with the management company. The police officer is not authorizing the tow usually when they say that, because if they authorize the towing carrier would just remove the vehicle. The police officer, when it's not their butt in the fire on the towing, can say all kinds of things. It doesn't mean that the towing company is going to yank the car. And that's something that's been very interesting. I don't see police officers ordering a tow on private property in the ordinary course of parking regulation. Now, they're going to order it if it was in an accident or if it's being investigated for use in a crime or it's stolen. Yeah, that's different. But as a general rule, the police are going to, in my experience, suggest that the association's towing burden is a lot lower than it is. And partly because they tow vehicles all the time, and partly because they're not responsible for it. So be careful when we have the police involved. It's always a good thing to have the police involved. I think just be careful when they say, oh yeah, you should be able to just tow this. That's not necessarily authorization for the tow, and we don't want to get in trouble by believing that it is. You also don't have to give 24-hour notice if the vehicle is blocking access to someone's driveway, or if the vehicle obstructs traffic, or if it's parked in a fire lane that is properly signed fire lane immediate tow, or if somebody's trespassing, somebody's parking in someone's deeded or limited common element parking space, then that tow does not need 24 hours. In that case, usually, not in every case, but in most cases, my default position would be to have the owner whose space it is authorize the tow. Is that legally required? I don't think it is. The manager or the board could still do it. Just have to recognize that towing is contentious and it often results in litigation. Signage. Oh my gosh. It's possible. We can do the signage, not we, the lawyers, but signage can be done. Very specific, extremely specific. And I know of several lawsuits out there going on right now about the signage. So your towing company should provide the signage. If they don't, or if they do, you still want to verify that it's accurate because it has to be in English and Spanish. It has to have the international tow symbol. It has to have very specific magic words in the signage. The reason I was stammering at the beginning of this is because it makes you wonder, how big the signs ultimately have to be to include all this information. It's not the end of the world. It's just has to be done exactly. And you have to post it carefully. That was a double slide, wasn't it? Yep. Sorry about that. You have to post it at the entrances to the parking area or the area where it's subject to towing. And then it has to be posted where it's going to be towed from, facing the place where the people would park. So if it's in a parking lot, you'd have certain signs on the way in, and then you would have it inside the parking area facing where people park so that they can see them. Can't be less than 3 feet tall, can't be more than 10 feet tall. I mean, all of these requirements are important. So just beware that when you tow, the signage and the policy, those are the first things that we have to get placed before we start towing. Okay, let's talk about the booting law. That was a new law. And booting is interesting to me, to I guess a large degree. Maybe I'm wrong, but we're trying to change behavior without creating an extra parking space, right? Because the vehicle is immobilized and stays where it is. And, I think it's probably less risky from a absolute liability perspective. When you tow someone's car, they've got personal property in there and they're going to claim damage. And if the towing company did not properly photo document the tow before it happened, including where the vehicle was in relation to the signage, then the law says that there's a rebuttable presumption, meaning you're guilty unless you can prove yourself innocent, that this towing carrier damaged the vehicle. And so when we leave the vehicle on the property and we don't take possession of it, we don't get into the vehicle, I think it reduces the liability. Problem is, it doesn't free up the fire lane, right? It doesn't free up the visitor parking, doesn't free the obstruction. So that's kind of the pro and the con. And for a while, booting kind of ran under the radar, although we have some clients that boot, but I don't think I've ever really gone to the mat over booting. I have defended a number of full day trials on towing, and it's crazy town in some cases. So just know that booting is now regulated. They have to have a Public Utilities Commission license, just like you would have to if you were a towing carrier. And again, they call it vehicle immobilization law, and it's still within the towing section. It's just at a further higher number in the 800 series. Similar documentation, prior notice. You need not same signage, but similar signage, just as precise, very clear on how tenants in apartment houses have to get policies on the booting. I take that to mean that we would do the same for our owners and our tenants. So be careful on the documentation. And the notice is similar to towing. So it's something that you can do. It's not outlawed, but it's highly regulated as of 2025. So whether it's towing or booting, we want to make sure that we've done everything we can to adopt a policy, not only to find out where in our governing documents it says they can't park here, have a policy that says towing. We work with a very reputable towing company who will help us presumably get the proper signage. We will give owners lots of notice. Tows or boots will be highly, rigorously documented prior to being done. And then we'll do everything that we can to be reasonable on the back end. So that's it in a nutshell. I'm going to turn off the recording and try to answer your questions.